Hey guys, it's Kathy. I hope you're doing well. I have a clip about in Colorado with the judge in Colorado that we love. Um, we don't get to see a lot of him because I like he runs a great courtroom. Nothing really happens in his courtroom. Nothing. Uh, they go in front of him. They do what they're supposed to do. They leave. Um, he does a great job. He just does. So we got an interesting case in front of him today. Nobody acts crazy or anything. It's just a frustrating case. It's just frustrating that we have to settle. We have to settle for less than what we should have gotten from this, and it's all about gangs. This gang did something that could have went unbelievably terribly bad, and it did go unbelievable. I mean, I'm telling you, it did go terribly bad, but it could have gone so much worse. I don't know. I'm sure the family of the victims don't think that it could get much worse, but it could have. It really could have. It's just so horrible all around. And it's horrible that we can't get justice for something like this, just because of the nature of gangs and how intimidating they are. But let's just look. Let's just go. The judge is outstandingly cute, so that helps. There we go.
Thank you. Good morning, Mr. Martinez.
Good morning, Your Honor.
We are calling. Oh,
It's for the victims.
yeah. Thanks. We'll wait just a moment. Okay, great. Thanks. We are calling 22 CR 822 People versus Martinez. I'll take entries starting with the people.
Good morning, Your Honor. Shannon Elwell and Kimberly Hinton appearing for the people. I would also note for the court the presence of the deceased family in the courtroom.
Thank you. Good morning, everyone.
Good morning, Your Honor. Danielle McCarthy and Christopher Braddock appearing on behalf of Mr. Martinez. He does appear in custody today.
Thank you. This matter comes on for sentencing. Ms. McCarthy, are you ready to proceed?
Defenses, Your Honor. Thank you.
And Ms. Elwell, are the people ready to proceed?
Yes.
Thank you. Any amendments or corrections to the PSI from either party?
Not from the people.
Not really from defense, Your Honor. Just
Okay.
argument.
Thank you. Okay. Ms. McCarthy, you may go ahead.
Thanks, Your Honor. And Your Honor, if the court would allow, before I get into my full argument, I know that Mr. Martinez's mother would like to make a very brief statement if the court would allow her to do so.
Of course.
And as we've seen 100 times, moms don't always make things better.
Why don't you just step in?
Good morning, ma'am.
Good morning, Your Honor.
Before you start, can you just give me your full name, please?
Yeah. Good morning. I am Alina Martinez. I am the mother of Rafael Martinez. I would like to acknowledge that throughout this whole process, I have not only prayed for my son, but I've also prayed for the healing of all victims and the families that were affected in this case. As for my son, I raised my son to be a good man. And while the court may view him differently because of these charges, I know who he is, and he continues to show me every day as he looks to God through this process. I know he will continue. And while the extreme conditions of the sick world we live in has brought him to where he is today, I know he has a beautiful heart. This is not just in the words that I say, but it's an energy that you can feel and a light that you can see. And no matter the tribulations that he may go through due to this, these qualities will always remain because those come from God. We will continue to trust God through this process, and it is in His name that I ask for your grace and mercy today. And thank you for your time.
Thank you, ma'am.
We're not thinking bad for him because of the charges. We're thinking bad about him because of the crimes.
Thank you, Your Honor. And Your Honor, I know that ultimately the court has accepted the stipulation of 6 years YOS. Of course, it's up to the court regarding that pre-sentence confinement time. And Of course, defense is asking for all of the pre-sentence confinement time. The PSI has it at 387 days, and we do agree with that number. First, I want the court to know that who Mr. Martinez is today is a very different person than the Mr. Martinez I met when this case began. There's been a lot of self-reflection. There has been a lot of processing in realizing how terribly everything went that day. And the fact that not more people were shot and killed is basically a miracle. Mr. Martinez was shot. He was shot in the back. He was shot very early on when the shots began getting fired. That injury itself may have saved his life. Unfortunately, the victim and all of the victims, more than one person was shot, more than one person was injured, and of course, the deceased was just an unfortunate situation that happened to him that could have happened to so many more in this very small area with many guns, with a lot of shots fired. Mr. Martinez has grown throughout this process, not only age, which age will do that, but also the time he spent in jail on the front end of this case. And then the decision he had to make as a person once his bond was posted. I want the court to know that the jail time has not been easy for Mr. Martinez. Unfortunately, there were some medical complications on the first round of jail, where he was injured by another inmate. He had to have surgery. The jail did not properly care for that incision. There was an infection, and that certainly contributed to his bond being reduced because there was a lot of concern that he was actually going to lose a part of his body based on that. Once he got out, he sought medical attention, was able to recover, but it's his actions when he was on bond that speaks volumes, Your Honor. Raphael did very well on bond. He lived with his mother. He spent most of his time at home, completely changed his friend group, had very little friends. I know he was a bit scared to even really participate in society, but for holding a job. The one, I guess, change, if you will, from the PSI was the moving company that he worked for. The PSI states 2 to 3 months, and it was actually about 12 months. So I want the court to know that Raphael was working very hard, and he was working hard to pay for his bond because he didn't want his mother and family to have to pay for that. When this offer came about, there was no hesitation. Mr. Martinez, from the time I met him, even when he was in a more immature state, took responsibility for his actions in this situation.
No, he didn't. And of course, he took the offer. Of course, he did. You'll see.
He has grown to really be able to express a level of remorse. And I think he did so very eloquently in the PSI. And he understands, and I know himself prays for the victim and the victim's family, as he, since maturing throughout this process, has turned back to God and become in touch more with his spirituality. Mr. Martinez has no intention of going back to the same life that he left when he was arrested on this case. He, as a young man, he knows the only way that he can make things better is really to work on himself. And he's done a pretty good job with that so far. He understands the opportunity at YOS. He is ready to start YOS because they have education. will get his GED. He will continue to take advantage of the programs that they have. He will participate in therapy and treatment and take advantage of the opportunities that have been offered to him. The facts of this case really revolve around the gang culture. And I think it's important to note that this did not happen because of a gang disagreement or a gang fight. However, this is a textbook illustration of what happens when gang members or those running with gang members have a situation presented to them where those outside of the gang culture would have reacted differently. Almost everyone had guns. And but for that gang involvement or being close to the gang, I think it's unlikely that the reactions would have been that way. Mr. Martinez and the others were all very young. He continues to be young. But I know through maturity and the self-reflection and the treatment and therapy that he'll receive at YOS, he will learn much better coping skills and how to properly react. I can tell the court that after Mr. Martinez completes and takes full advantage of that YOS opportunity, that the family intends to move out of state closer to other extended family. And I think that that would be good for everyone involved.
Stay away from Pennsylvania.
I don't know how much more I can say about Mr. Martinez. I think that his level of remorse and how he did on bond speaks for itself. He's very motivated to do well, to be a productive member of society. And he understands every single day the impact that he's had on the victim and the victim's family. That is not lost on Mr. Martinez. We are asking the court to impose the full 387 days of pre-sentence confinement time. Most of that time, as the court knows, was on the front end of this case. I know Your Honor was not presiding over the case at the time, but I wanted to highlight the issues and the medical issues because, again, that was hard time, particularly for an 18-year-old. He never went to the juvenile detention center. But Raphael's ready to move forward and to be productive. He's ready to do whatever he can to make up or to help with the actions that he's caused. We understand the restitution, I believe, is $12,144.08. And Mr. Martinez has no objection to that restitution. So we're asking the court to impose that 6-year YOS sentence with the pre-sentence confinement time of 387 days. I know Your Honor has already sentenced one of the co-defendants, which of course was just late last week. He did receive all of what I assume to be all of his pre-sentence confinement time. And because Mr. Martinez did so well on bond, has done really well in jail since the plea in this case.
That's not true.
We're asking the court to reward him for his behavior.
Thank you, Ms. McCarthy. For the people?
Thank you, Your Honor. The victim's sister would like to speak to the court. Melissa.
Please.
Let's go back.
Good morning. My name is Melissa. I'm Ronald's sister.
Thank you.
I honestly feel like 6 years is nothing. I feel Mr. Martinez doesn't have sympathy and doesn't regret and doesn't feel sorry for killing my brother. I saw a video where he was very proud of what he did. And I honestly feel 6 years is nothing. He killed my brother. My brother would have been a dad. He is a dad, but he's not here. I feel like it wasn't fair for them shooting my brother. I just honestly feel 6 years is not fair. It's really not. He doesn't feel sorry for what he did. I know he doesn't.
We're going to find out why it's only 6 years, and you'll see why.
And yeah, that's all.
Thank you.
There's no one else from the family.
Thank you. So,
Thank you. Your Honor, just to back things up a bit, I think it's important to remember here what the charges were. The defendant was charged with murder in the first degree and 3 counts of attempted murder in the first degree. He did plead to an added count 5 of murder in the second degree, heat of passion, a class 3 felony crime of violence. And the court accepted his stipulation of 6 years in YOS with 21 years of DOC suspended. And there was no stipulation to pre-sentence confinement credit. Let me be clear. None of the defendants deserve a sentence to YOS on the face of this case alone. The offer was made given the people's inability to obtain witness cooperation and attendance at a gang trial. We believe it is appropriate, however, given the disappearance of necessary and essential witnesses to the crime, as well as witness safety issues that are the 2 trials of the juvenile accessory. The defendant pled to murder, and that is what happened here. We are VRA compliant to proceed. As the court can see, Ronald Calderon Ramirez's family is present, as they were last week. We are VRA compliant with respect to the other 3 victims who have been too scared to come forward. The court is aware of the statute that governs here, CRS 18-1.3 407.5, that states that the awarding of pre-sentence confinement credit is discretionary to impose and refers back to 18-1.3 407-2A1. Your Honor, we are asking that the court grant the motion to impose restitution joint and several as it is unopposed and has been previously filed. Your Honor, March 9th, 2022, the defendant made many choices. He chose to attend a pool party at the Quality Inn and Suites in Aurora, Colorado. There were multiple victims here of this crime. The pregnant lay witness, Tiana Guerrero, she was shot. She testified twice at the accessories trial. After she testified, she received graphic photos of her deceased boyfriend texted to her from Discovery.
That's why. No one's coming forward as a witness or anything because they all have been scared off.
We were unable to determine who did that, however, because she subsequently went in the wind and we have not found her since. There were 2 other women who were shot, and Ronald Calderon Ramirez was killed. It is clear from the video footage and the evidence that yes, there were multiple guns at the pool party that day, but not a single one was fired until after the defendant and his friends showed up and escalated tensions. They are the only ones who came to the pool party masked up, all in black. The co-defendant accessory was terrified of the defendant, and he only pointed to his name when interviewed by law enforcement. When law enforcement asked if there were any gang members present, he pointed to the defendant's name as a gang member. During the interview in the proffer, he told police that they had received a call from an original shot caller 15 member of the Only the Family crime gang, telling them to come to the pool party and hurry up as backup. He told the police that 3 out of the 4 of them were carrying guns, including the defendant, and they masked up just in case. Judge, they walked in there ready to fight. The situation was not presented to them. They walked in there and they created it. They were not there to attend a pool party like the other people. They were there to finish it. The lay witnesses who have since become uncooperative were crystal clear that the defendant and his co-defendants were the primary aggressors and the first shooters. This is also borne out in video. The scene was processed and a total of 34 fired shell casings of various calibers, 9mm, 40s, 45s, were recovered. 6 of them were attributed to the 45 caliber gun. Additionally, 16 fired projectiles along with 5 bullet fragments were recovered. The victim was shot 7 to 8 times. As I stated, the victim Tiana was shot once, and 2 other victims, Swallam and Serena, were each shot once. The clerk at the hotel ducked, ran, and hid in the employee break room to avoid being shot. The bullets entered through the wall, and they lodged in the wall and in furniture that was at waist-high level in the employee break room. They also sprayed throughout the pool area and into the gym. It is surprising, frankly, that more people were not hit or killed. When I went to that pool area, Judge, I can tell you I was shocked by how small it is. And it was an absolute gunfire that day. Detective Marino wished to be here today, but he was out late last night on another case. However, he wanted me to convey to the court, similarly, that this tragedy could have been so much worse with the confined space and number of people. The defendants hid the murder weapons in a bush once they were contacted by police. They never disclosed their involvement in the incident until the police discovered the surveillance footage, showing that they were the shooters. The firearm that was ultimately attributed to the defendant is a 45 caliber Glock with a DNA profile of at least 5 contributors detected. What that means is it was not suitable for comparison. However, the defendant was excluded from the contributors to the other murder weapons on the scene, and we know he was carrying and firing a gun from victim and witness statements as well as video. Similar to the hoodie we know he was wearing, there were too many contributors to the hoodie to be suitable for comparison, but we know from the video and the evidence collected that he was wearing it. What that tells us, Judge, is he fired at least 6 times. He made the choice to be a gang member. He made the choice to go to the pool party that night, armed with a loaded gun, masked up, to back up his shot caller gang member. He chose to fire 6 times. Your Honor, a lot was made about who the defendant is. And I submit to the court has seen the defendant's Facebook records that show exactly who he is. He sold and traded weapons and drugs on Facebook. He talked about shootings and murders. His jail calls show continued associations with known gang members. He is a clear danger to the community. He was only released on this case in January of 2023 because he was involved in a fight in the jail and unfortunately suffered the loss of an organ as a result. As Judge Kisnowski stated, it was a gang fight in the jail. Let's all be clear, Ms. Elwell. That is what he said to me, and it was. To summarize, of note, Judge, he is the only adult that was charged here. He was the only adult there. He is the only known member of the gang OTF known to law enforcement of that entire party. He denies in his PSI that he is involved in the gang. He only says he is associated with the gang via peers. That is simply not true. Contrary to the evidence, the statements of the co-defendant juvenile accessory, and the defendant's behavior during the pendency of the case, the defendant is a member of OTF. This court has actually found as much, based on evidence presented as part of the People's Rojas and 404B motion. The defendant was legally found to be a member of OTF. I'd like to talk about the similarities and differences between the defendant and the victim here. They were both young men who were victims of senseless gang violence. They were both young men who came armed to a pool party, but one came with his pregnant girlfriend to hang out, and the other one came as an enforcer. They were both shot. One was shot multiple times, and one was shot likely by friendly fire based upon the video evidence at the scene. One died and one lived. Ronald did not deserve to die. Despite any gang affiliations he had, he did not deserve to die that day. He was a friend, a father, a young man, a son, and a brother. His life was tragically taken from him in a veritable shootout and bloodbath, instigated by senseless gang violence. His life was forever irrevocably altered and ended. The defendant's was also forever irrevocably altered, but he still has it. He still has a chance to be with his family. That chance was not afforded to Ronald Calderon Ramirez. His family, his son, and his child's mother will never have the chance to spend another day with him. Your Honor, the court did sentence Damian Lucero to the stipulated sentence and awarded all of the pre-sentence confinement credit to Damian Lucero. However, the differences here are stark. Damian Lucero received 1 additional year in YOS because of the statute. Damian Lucero was not a documented member of OTF. He was a self-professed fat kid that played video games in his basement and hung out with other known gang members. Damian Lucero was a juvenile. Rafael Martinez was an adult. He was a known, documented member of OTF. And yes, this court absolutely should address the defendant's behavior, but not reward him for it. Given that the defendant is the only adult charged here, Judge, and given the level of his involvement in the reasoning for this murder, we are requesting that the stipulated sentence be imposed with no granting of pre-sentence confinement. Thank you.
Thank you, Ms. Owen. Mr. Martinez, anything you'd like to let me know, sir?
Yeah. Yes, Your Honor.
I don't even want to hear from him, but I know that's the way the law is. We got to give him a chance for his defense. But he posted pictures and videos on Facebook after this about shooting and killings and gang activity.
I would like the courts to know that I did not know Ronald at all. I didn't know any of his affiliations. Now I'd like everybody in the courtroom to know that I do sincerely apologize for my actions that night. I do understand the wrong, and I would like mercy on this case.
Thanks, sir. Thank you, everyone. Consider the arguments and statements of both parties of Melissa, Mr. Calderon's sister, Mr. Martinez's statements, and I've also reviewed the PSI and, of course, familiar with the facts of this case based upon pretrial litigation. As Mr. Calderon's sister said, this is not fair. If I had the ability to bring about true justice here, it would be bringing Mr. Calderon back so that his family, his son, and everyone who cares about him could have the time with him that they deserved. But Mr. Calderon's life was cut short. Ms. Gutierrez, Ms. Valdez, Ms. Guerrero were shot in this incident. And that was in part due to the actions of Mr. Martinez on that day. And the harm here, of course, goes well beyond just the people that were there to Mr. Calderon's son, his family, his friends, this community. And of course, Mr. Martinez also does harm to his family as they are now in the position of watching their son before the court for sentencing. And also, as Mr. Calderon's sister said, 6 years, I'm sure it feels like nothing, given the harm that happened. And frankly, there's no punishment I could give that would even compare to the harm that was done here. However, of course, the offer that was made, I did accept. And I do have to take into account that Mr. Martinez, though an adult, was certainly a very young man, and the practical distinction between someone 17 and 18 is very little apart from the significant legal implications. I did accept the sentence and the stipulation, so I will sentence Mr. Martinez to 6 years in the youthful offender system. I will suspend 21 years of Department of Corrections. Mr. Martinez was accepted via ward and determination to the youthful offender system. And as Ms. McCarthy noted, while still imprisonment, still run by the Department of Corrections, it does have a number of opportunities for Mr. Martinez, and I do hope he takes advantage of those. The real consideration for the court is as to the pre-sentence confinement credit. As both parties noted, I sentenced Mr. Lucero, a co-participant, last week. And as noted by Ms. Elwell, a significant factor in that decision was the fact that Mr. Lucero was facing a 7-year sentence based upon the nature of the plea in the statute. I've also considered the fact that Mr. Martinez was somewhat older, but more importantly, more involved with the gang and the gang culture there. Mr. Martinez, I appreciate your statements this morning. I think it's certainly fair that Mr. Calderon's family may or may not accept those. And it sounds like some of the act really undercuts the accountability you're taking today. But I still do think you're sincere in it today. And furthermore, I do believe that people can change, and I sincerely hope you have changed since those actions and since any statements made following that, as well as the activity in the jail. And I hope that you'll continue to change, Mr. Martinez. You have the opportunity to continue to grow and mature that Mr. Calderon does not. And ultimately, you are going to be part of our community again, whether it's here or whether you relocate. So I sincerely hope that you make every effort you can in the youthful offender system to make sure this never happens again, both for yourself and for anyone else in your life that you have the chance to affect. There's nothing that can undo what happened, and I'm so sorry to Mr. Calderon's family. I can't imagine every day must be like with that absence, and I'm very sorry. Given all of the considerations here, most importantly, Mr. Martinez's involvement in the OTF gang, his age, and the fact that he's facing a 6-year YOS sentence rather than 7 years, I am going to deny the request for pre-sentence confinement credit. So it will be the full 6 years. Again, Mr. Martinez, not to discount the medical issues that you went through, but I do think that is appropriate. And on balance, looking at the other co-participants as well in Mr. Lucero's sentence. There's been no objection to the motion for restitution. I have reviewed that and find good cause to grant that. So I will grant the people's motion to impose restitution. That will be joint and several with Mr. Lucero. Ms. McCarthy, anything further?
Yeah, we're asking the court to consider giving Mr. Martinez the 63 days that he's been in custody, since there's no way we could go to immediate sentencing at a plea, even though it was stipulated, solely for the purpose of that warden's determination letter. So at least if we backdated, that would give him something from this prior time, since it wasn't possible for the parties to go forward without the determination letter. So I'm asking the court to consider that.
Okay, thank you, Ms. McCarthy. Ms. Elmon?
We defer to the court.
Okay, thank you. Again, noting that 6 years is nothing compared to the harm done, but I do think it's an appropriate request, given that otherwise there may have been the opportunity for an immediate sentencing. So I will reconsider my rulings in part, and I will grant 63 days of pre-sentence confinement credit towards the 6-year sentence. Ms. McCarthy, anything further?
Give it more.
I don't think so, Your Honor. Thank you.
Thank you. Ms. Elmon?
No, thank you, Judge.
Okay, thank you, everyone.
Thank you, Your Honor. Have a good day.
He messed up and went into a hotel, to the pool area of the hotel, right beside the employee break room, right beside the gym, and then started firing. Everybody started firing guns. 3 people got shot and injured. 1 person got shot and killed. It could have been way, 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 way worse. But it's still really bad. And he only got 8 years because the witnesses that came to testify were intimidated by the gangs. So there's no witnesses. The prosecution has no case. I mean, they have the video. That's why they got 6 years instead of life. There's one good thing about this, though. Even though it's sickening, there's one good thing about this. He has 21 years suspended sentence. If he messes up on probation. Sorry. Then he's going to spend 21 years in jail. Thanks for coming out, guys. I really appreciate it. My dog says it's time to stop now. I'll see you next time. Bye.